Well, hello and welcome. I'm Alison Kirkland, CEO of the Women's Enterprise Organizations of Canada, and we're so glad to have you joining us here today. We are back with Giselle and Catherine for another great session in our IP series. So this is the last English session we have before the end of the year. We have another one coming in French, and then we'll be starting some new programming in early 2021. And look forward to seeing you all at that point. But today we are going to explore IP and traditional knowledge, and I think this is a really interesting topic and something that obviously is quite appealing to all of you because of the registration that we had today. So while not everybody here is able to join us right now, I know there's lots of interest in the video that we will share with everyone afterwards as well. So I am not going to talk much further other than to thank the team at the Women's Enterprise Organizations of Canada for bringing us together with Giselle and Catherine. It's been a great partnership, and thank you to them for working with us this fall, and we look forward to doing more work with you in 2021. Thank you to Lindsay and Aricia and Jessica for your support and sharing all of this information with our network. And thanks to all of you for being with us. I was going to say this afternoon, but it's all times across the country. So wherever you are, welcome. And I am going to turn it over to Giselle.
Perfect. Hi, everyone, and good afternoon. So myself, Giselle, and my colleague Catherine will be delivering this webinar today. Again, as Alison mentioned, it's part of a three-part series. This is the third one in intellectual property, and today we're going to focus on traditional knowledge and introduce commercialization. Alison also mentioned there is a French session of this webinar coming up in December. It's December 17th, and that'll actually be delivered by Catherine, who will speak shortly. So we'll get going. The way I think we've worked in the past is if you do have any questions throughout, you can type them in the chat, and we'll try to get to them if we can as we're doing the presentation. And if not, we'll review them at the end of the presentation, where we'll also, if we have time, leave some room for some Q&A. And just make sure we can address those questions. If for some reason we run out of time, we can follow up with those questions afterwards. So I will get going. And I'm just going to try to share the presentation. Just give me one moment. So I am having some difficulties sharing the presentation. Just give me one moment. We'll sort of. So I'll just need to be made, I think, the host in order to share the presentation. So sorry about this again, folks. Everyone will just wait a couple minutes. Again, just some technical difficulties we're working through here. Okay, great. Looks like we're up and running. So again, today we'll be speaking about traditional knowledge and intellectual property with a focus on commercializing your innovations. So today's agenda, it's our goal to provide general information on the intersections between traditional knowledge, intellectual property, and traditional cultural expressions. And as I mentioned, we'll introduce the topic of commercialization and how you can leverage some of these IP rights to extract value from those innovations through commercialization methods. specifically. We'll provide you with an overview of traditional knowledge, what it is, how you can benefit from the IP system. We'll discuss some Indigenous and local community creations that can benefit from the IP system as well. And finally, some different commercialization methods. I'll just begin quickly by telling you a bit about CIPO. So the Canadian Intellectual Property Office is responsible for the administration of most Canadian intellectual property rights. At CIPO, we register and grant IP rights such as trademarks, patents, copyright, and industrial designs. IP rights are territorial, so it does vary by country. So depending on the country where you're looking to secure these IP rights, you would have to seek that appropriate IP office in that country. Our overall goal is to increase the awareness of the effective use of IP through different activities and resources, such as this webinar that we are delivering today. We have key focus sectors, which include agri-food, clean technology, digital technology, health and biosciences, and advanced manufacturing, with a special focus on underrepresented groups such as women and Indigenous entrepreneurs. So, traditional knowledge. There is no universal accepted definition for Indigenous knowledge and cultural expressions. However, the World Intellectual Property Organization, or WIPO, does provide a good definition for both. When it comes to speaking about IP, the terms generally used are traditional knowledge and traditional cultural expressions. When we refer to traditional knowledge, we're talking about the know-how, the skills, innovation, and practices developed by Indigenous people. And traditional cultural expressions, we're speaking about the tangible and intangible forms in which the traditional knowledge and culture are expressed, sustained, and passed on from generation to generation within a community. So this could be through ceremonies, dance, artwork, and many other activities. So how can you benefit from knowledge of traditional knowledge and the intellectual property system? So having knowledge of both TK and the IP system can provide Indigenous entrepreneurs with greater options in order to promote and protect their creations. This includes selecting the best means for dissemination and transmission of that knowledge in order to protect and preserve access to this traditional knowledge. Existing IP rights may be useful for preserving and protecting this knowledge. We will get into the different IP rights. Not all will work for the different types of Indigenous creations, but we will touch upon a few examples where it has worked. We will also identify opportunities for commercialization through means such as licensing and contractual agreements. And this is actually very important because today there's a ever more increasing demand for authentic products in the marketplace. So this is why we're going to speak about commercialization later on. And here we're going to look, given that traditional knowledge has a wide range of commercial and scientific uses, it's becoming increasingly valuable amongst non-Indigenous outsiders. For example, traditional medicines are used as a basis for developing pharmaceutical products and herbal remedies. So here we're presenting two different approaches for IP protection: defensive protection and offensive protection. Defensive protection aims to stop people outside the community from acquiring IP rights over traditional knowledge. One of the activities included in this approach is monitoring the marketplace for the use of traditional knowledge by non-Indigenous businesses. India, for example, has compiled a searchable database of traditional medicine that can be used as evidence of prior art, that can be used by patent examiners when assessing patent applications. In other words, there's evidence that the invention is already known. So this actually follows a well-known case for the U.S. Patent and Trademark Office, which granted a patent, which was later revoked, for the use of turmeric powder to treat wounds. Turmeric powder is a property well known to traditional communities in India and documented in ancient Sanskrit texts. And therefore, the argument was that it lacked the novelty criterion that is required for patenting. Offensive protection is the granting of rights that empower communities to promote their traditional knowledge and control its uses and benefit from its commercial exploitation. So now we'll introduce the topic of commercialization. The commercialization of intellectual property is making money out of one's ideas. As such, an idea has no value until one makes it into a tangible object, and its utility has been proven such that others would pay to use it, to see it, recognize, or listen to that product. The World Intellectual Property Office, WIPO, defines commercialization of intellectual property as a continuum of activities and actions that provide for the protection, management, evaluation, development, and value creation of ideas. Prototypes and implemented processes lead to the development of products and services by entrepreneurs and startups and other existing companies, as well as governments, which result in economic and societal benefits. But not all businesses do IP commercialization. For example, a farmer or a fisherman and other producers may have very little IP to commercialize, if any. One way to see the output and the value of IP commercialization is the relative value of intangible assets for a company's market value. So now we're going to look at the graph on the slide on the left here. So this graph shows the relative value of tangible versus intangible assets, including intellectual property, for a range of industries. So from this example, you'll see on the very far right, we have the energy sector, whose value lies mostly in the tangible assets. And this could be because they have, for example, mining sites or other natural resources. To the far left, we have the other extreme, which is information technology. Think of user interfaces, data, apps. So this industry, the value is in the intangible assets. And here it actually makes over 90% of that company's market value. So that was just sort of, we'll go into more detail on commercialization methods in later slides, but first I'll actually pass it on to Catherine now, who will go through a few of the different IP rights and that can be commercialized, and at the same time point out a few different indigenous examples.
Okay, great. Thank you, Giselle. Next slide, please. So I like to describe intellectual property as a toolbox because many people may have heard of a patent or a trademark or copyright before. And those are, in a sense, tools that help you protect different aspects of intellectual property. So within our toolbox, there's a whole suite of tools. If I was going to build a house, I would use different tools, and I might have different expertise and tradespeople. So an electrician will do a different thing than a plumber will, for example. So it's kind of the same way with our intellectual property toolkit. A copyright is going to be different than a trademark or a patent. And there are actually IP experts who, just like a plumber doesn't do the job of an electrician, a patent doesn't do the same thing or protect the same type of thing that a trademark does. So the traditional forms of intellectual property, a trademark, for example, is often referred to as a brand. A patent is often for I would like to say, if you can reverse engineer it, it might be an invention, something I can hold in my hand. It is broader than that. But if by buying that product, I can look at it and figure out how it's made, a patent might be the best tool for protecting that. Copyright, we tend to think of for books, for music, and creative works. One that often isn't as well known is industrial designs, which is more for how a product looks or the shape or design of something. There are also actually plant breeders' rights. So technically we have 6 tools in our toolbox, 5 that you would register and protect. And a trade secret is more some usually legal steps that you put into place to keep something a secret. You actually don't sign and register with anybody, but you put mechanisms in place. So that's kind of our suite, and I'll go into each of the individual ones one by one. Next slide, please. So trademarks, as I mentioned, tend to be the way most people imagine it, it's your brand. So it's a sign that, or a way of identifying the source of goods, whether it's product that's being offered or a service. And what you can protect with a trademark includes a symbol, a word, or a series of words, including a slogan, colors, shape, scent, video, and sounds. If I go do 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 do, a lot of people might know what jingle that company represents. Or if you see a U-Haul truck driving by, it has that band of orange with the name U-Haul. Well, that shade of orange is protected as part of their branding, and the position of that on the truck is also protected. So a trademark can protect quite a wide range of aspects of your brand. And it's a mix of both automatic use or common law rights, as well as registration. And what it does is it gives you the right to exclude other people from using your mark or your branding or something that is similar enough that would be deemed confusing. It gives you 10 years of protection across Canada, and it is one of the only forms of intellectual property that is renewable every 10 years indefinitely. If you think about popular brands that you'll find, labels in your house for food or laundry detergent or things like that, many of those brands have been around maybe 20, 30, 40 years, and they renew those to maintain the protection. And so I mentioned there's common law as well as registered. Anybody, as soon as you launch a product as with common law with no registration, you can put TM on a trademark to indicate that you're aware this has some value. The difference between using the R in a circle is once you have officially registered your trademark with CIPO, the Canadian Intellectual Property Office, then you gain the right to put the R in a circle. And there are several examples of registered trademarks that protect brands. For example, the Manitoba Mucklucks. So Métis entrepreneur Sean McCormick started off small, but grew his company to be a very well-known, recognizable brand, and that logo and name were protected so that people identify that company with the source of the goods. And often, as a company grows, they will register several trademarks. So usually a company, or sometimes even a startup, will start with what's called a word mark or the name, and then they will later on add a logo, maybe they'll add a slogan. And as the brand becomes more and more recognized, they broaden their portfolio of trademark protections to protect other aspects or broader aspects of the business. Next slide, please. So certification marks can be used again to distinguish goods or services, but that are of a defined standard. So it sets a bar, for example, for the character or quality of goods or services. It can be also for the working conditions under which the goods have been produced or the services performed. It can be by who the people are producing those goods or the services performed. And also it could be a geographical area where the goods have been produced or the services. So for example, the Igloo tag trademark is a certification mark to protect artists and deem works, or if I'm a purchaser who wants to buy a piece of Inuit art, that it's certified as authentic. It's not a copycat. It wasn't made in China. It comes from a known source of those goods. And it's actually owned since 2017 by the Inuit Art Foundation. And so that's a category of trademark. And it's really important to kind of guarantee or serve as a stamp of approval of authenticity. And it can only be registered by an entity who's not engaged, or the person manufacturing, selling, leasing, or hiring. And the registered owner controls who can use that mark. If I'm not mistaken, also the print studio on Baffin Island has a certification mark, again, linked with Inuit art. So it certifies a source and quality of goods that has been vetted in some way. Next slide, please. So geographical indications are also used for the origin of where did something come from geographically. We often see it as an example for food products. So champagne, for example, has to come from the Champagne region, or corn, the maïs sucré de Neuville, comes from a very specific location on the St. Lawrence River, west of Quebec City. And it's limited in order to use that branding or that label on what is being sold, in this case, the corn. It has to have come from that particular area. And it's similar, if some of you are familiar with the term in French of a terroir, which essentially means the land of origin. So something has to come from a very specific geographical area. And again, for that, we are the organization to whom you apply to have a geographical indication approved or listed. And there is a list of what are the regions and what types of products are associated. So as mentioned here, it could be wine, spirits, agricultural products, food, and things of that nature. And again, it's usually applied for by an authority or a collective of people as opposed to one individual. So right now, we don't have any Indigenous geographical indications in Canada, but there are possible Indigenous agricultural products and foods that could potentially qualify for this type of protection, and may or may not, be worth exploring depending on the circumstances. Next slide, please. So as I mentioned, trademarks can come in many forms. One of the quite common forms is a logo. And so these are examples here of many trademarks that exist in an Aboriginal context and that have been registered for protection. And part of the trademark protection also, you describe what types of goods or services are to be protected with that. So you think of it as building a fence to say, Is it going to be artwork? Is it going to be food products? Is it going to be tourism in the tourism industry? In what sector? And what are the goods and services that are associated with that trademark and with that brand that are going to be protected? Next slide, please. So patents are often one of the tools that I hear mentioned when people talk about intellectual property, and they are quite powerful as a tool. The bar to patent something is quite high in that it has to be new to the world. So if you've got something you want to protect with a patent, or not me per se, but the patent examiner can't go and do a web search and find what it is you're applying to patent. So you have to keep it a secret before you apply, and it has to be new, as in new to the world. It has to be useful in that it has to work. It can't just be an idea or a prototype that doesn't actually work. And it can't be obvious to somebody who's skilled in that same field or space. So that's an important principle of a patent. What a patent does give you, assuming you meet all those criteria and it's eligible for patenting, you then have the right to exclude others from making, using, importing, or selling that exact invention that fits the description of what you've protected. And here you get a 20-year protection from when you file. After that, though, it expires. And if you stop and think about it, in pharmaceutical medicines, they are usually patented. The pharmaceutical company gets protection for 20 years in exchange for fully disclosing and revealing what it is and exactly how it works. And they get more or less a 20-year head start on the market and selling. Once that expires after 20 years, and this is not renewable, then that's how you get generic drugs. So you get 20 years of protection, but then it's open to others to use what was originally patented and protected. And if something is disclosed, so let's say you created a product and you launched it, as long as you apply for your patent within 12 months of launching it, you could still apply for a patent. After 12 months, though, however, you no longer can. So an example of this is a company started by Arnold Asham, and he made innovations in the curling industry. And they have come up with new and innovative ways to design and make curling shoes and brooms. And often a good test of, I'll get asked, like a client might come to me for a consultation and say, well, I don't know what to do. How do I protect what I have? And I say, well, if somebody were to buy your product, could they reverse engineer it? And could they reverse engineer it easily? And if it doesn't exist already anywhere else in the world, then yes, a patent may be the best tool to protect what you have. I think that's probably all I'll cover on patents. Thanks, sorry. Next slide, please. So copyright is another really powerful tool in the intellectual property toolkit. It protects creative works, and we often think of it in terms of whether it's music, and that can apply to both the lyrics or to music for the notes. It can be dramatic performances, it can be choreography, it can be artistic works. And again, if you think about it and break down the words, copyright is who has the right to copy. Because as the creator of an original work, you maintain the right to decide who else can publish, translate, perform this particular artistic work. And it's automatic upon creation. Now, it can be registered. You can submit a request to CIPO, and the duration of that protection is the life of the author or the creator plus 50 years. Sorry. I'm trying to run two screens with two mice, and then of course sometimes I'm going to the wrong one. So these types of protections that are available under the Copyright Act have actually been widely used by Indigenous artists, performers, composers, and writers of traditional-based creations, such as wood carvings and sculptures from Pacific Coast artists or Northern artists, masks, totem poles, the silver jewelry of Haida artists, the designs on those would fall under copyright, the songs, sound recordings, sculptures, etc. Software, ironically, I know we're talking here sometimes about traditional, but there are a lot of people who are creating apps or software, and the code for that software is actually also considered a literary work and falls under copyright. So TCEs can also be called like expressions of folklore, and that can include music, dance, art, designs, performances, architectural forms, handicrafts, for example, and those artistic or cultural expressions would tend to fall quite often under copyright. And again, as Giselle mentioned, WIPO, or the World Intellectual Property Organization, has some really good resource material on how that applies in many cases to Indigenous circumstances to protect various aspects of what's important. Next slide, please.
Sorry, Catherine, just to jump in, we did have a question about a patent. I don't know if we can just quickly go back. And
yeah, sure.
Okay, so the question here is, if you see patent pending, what is the legality of that? Is there assistance when defending a patent?
So patent pending, yes, means that there's a patent that's being applied for. And in Canada, we work on the premise of first to file. And so what it means is it's kind of a flag to say to potential copiers, we've applied for a patent for this, heads up. If you plan to copy it, you might get in trouble, I guess would be the short answer to that. There are slight differences between the Canadian and the US system, but the short answer for Canada is that's what it would mean. And we can certainly discuss that in more depth offline or at the very end if that didn't answer the question. Thank you.
Thank you.
So here again are some examples of copyright in Canada, whether it's for a movie, whether it's for a sculpture, often from an artistic. I often think of more artistic works as falling under copyright. It's not quite as straightforward as that, but as a general starting point, that's a really good place to start. Next slide, please. So one of the areas or tools in our toolbox that not everybody even knows about, but can also be really useful, especially for craftspeople, is industrial designs, because it protects the visual appearance of a product. So, for example, it can be the ornamentation or patterning of something. So whether that's a fabric print or the shape of something, if that's what's truly important, then that can be a really powerful tool. And here, for example, is the West Baffin Cooperative filed more than 50 industrial designs in the late 1960s. And so the fabrics and the designs and ornamentation that are very traditional and recognizable. And again, think about, does it point to the source of the goods or identify in some way? And once again, with jewelry, we do see a lot of valid applications for jewelry or clothing in the industrial design database. And once again, with this type of protection, you gain the right to exclude others from copying, making, using, or selling a product. And once again, it's a registration for this in Canada. We call them industrial designs. In the US, the same tool or type of protection is called a design patent. This tool protects your design for up to 15 years from when you filed it. And then if you gain enough recognition and it's considered distinctive, you can actually convert that when it just before or shortly after it expires, potentially to a trademark. So there are examples of companies who have done this, whether we talk about the Gatorade bottle, the shape of the packaging, or Toblerone chocolate bar was distinctive enough that even without the labeling and the branding on it, people would recognize that as the source of the goods. And so it was then converted to a trademark under a special type of trademark. Now, once again, like with patents, you don't want to reveal or launch your product ahead of time. You want to keep it a secret before launching. However, there is a 12-month grace period in Canada. So if I launched a product in Canada with a new t-shirt design or leggings that had a very distinctive patterning, as you would have on a fabric, as long as I keep it under wraps or apply within the first 12 months of launching it, I would qualify to try to protect it and prevent others from copying it. Next slide, please. So another right that we don't deal with as often, but could be applicable in a context like this, is the protection of new plant varieties. So once again, they would give the applicant and the person who gets granted those rights the right to exclude others from using that particular variety of plants. Technically, the registration happens with the Canadian Food Inspection Agency, not CIPO per se, but it is a way to protect a variety of plant, whether that would be trees, vines, or different varieties that are used in different contexts. And once again, there's a 12-month grace period that if you launched and you didn't protect because you didn't know, you could certainly almost retroactively apply to protect that. Now, in Ontario, there is the Indian Agricultural Program of Ontario. So the IAPO is owned by Status Indian farmers in Ontario, and they've actually been doing some research on white Indian flint corn, which is a traditional corn renowned for its flour and high protein content. And their goals are to develop new varieties that can be registered under the Plant Breeders' Rights Act and similar protection and legislation in other countries, and to be able to market these varieties in North America and Europe. So that's another example. Next slide, please. So one of our final tools in our toolbox is trade secrets. So unlike the other forms where you actually send in an application to somebody my colleagues usually at CIPO or agriculture, agri-food, and other organizations, trade secrets really involve you keeping something a secret and not disclosing, and whether it's any kind of information that is proprietary or really important and distinctive to what you're doing. And the value in a trade secret does rely, though, in being able to keep these, to limit who has access to this particular knowledge or methodology for something. And that trade secret protection lasts as long as you maintain the secret and don't share it and disclose it. And should you have to disclose it, whether it's to get funding or something like that, then you really do need to get a legal document, a non-disclosure agreement signed to protect what it is that you've revealed to somebody else.
Catherine, can I just jump in with a question here on trade secrets?
Sure.
So we have a question for tech. Do aggregated data sets fall under trade secrets or models that are trained off of private data sets?
Data sets are a bit of a complicated area. The short answer is many of them fall under copyright as opposed to a trade secret, but it would depend on how they're maintained as to whether are they visible to the public or not. And it gets into some pretty complicated IP law. So I'm not sure if that really addresses it, but the two areas you would need to look at are more copyright as opposed to trade secrets.
Thank you.
So UNOC Fisheries is equally owned between two corporations, and they hold one of 17 offshore shrimp licenses in order to fish for shrimp in the northern shrimp fishery in Canadian waters. And both organizations are responsible for fishing their own 50% of the one license. So that would be an example of sharing of a trade secret and used by two different organizations. Okay, I think the next slide, I'm going back over to Giselle, please.
Okay, thank you, Catherine. So now that we've gone through some of the different IP rights and some examples of how those have sought out protection using these IP rights, we'll continue back into commercialization and a few of the different methods. So when you're putting together a plan of how to leverage these IP assets, it's important always to start off by weighing the pros and cons. So that's what this table summarizes. On the left, you have the different entry methods or different forms of commercialization. The first one, for example, sales. If someone is selling goods directly to a customer in the target market, whether that be an importer, a wholesaler, distributor, it may mean that the local customer has a great deal of control of the sales and the sales efforts. A company can also export indirectly by working with an agent. So for instance, a Canadian intermediary. However, by expanding your reach, you just need to be prepared to give up some of that control you would otherwise have if you yourself were setting up a local office in the target market. Another mode of entry is licensing. This is another good way to increase your reach. For example, a company can allow a licensee or franchisee to use all or parts of a bundle of IP rights. So use a part of the product or sell the full product. All of that would be in a licensing agreement. So the terms would be set out up front of how they can use that product or sell it. It can be a faster way to reach a bigger market. But again, since now you're spreading that responsibility and passing that on to a licensee or a franchisee, only parts of the revenue will flow back to the company that owns the IP. This is because licensees will usually work off commissions. So you are now, the benefit is you're spreading the risk, but you will also not receive 100% usually of the revenue. Another form is through mode of entry is partnering. So a deeper level of sharing risk is to form a strategic alliance with another entity. This can be an effective way to tap into another company's capability and local presence. It allows you to leverage what the other company already has. So if they already have, whether it be an established market or a physical office in one of your target markets that's already established, that's going to save you time and money by partnering with them. One of the not really a con, but I guess just a complexity would be that now you have two entities, so there's two different corporate cultures that have to work together. So it is important when you are partnering with someone that you do pay special attention to IP agreements. For example, who is bringing what IP into the relationship? How will new IP be shared? For how long, etc. All of this should be identified, discussed, and agreed to upfront. Other forms of entering markets include acquiring an existing business and the IP that comes with it. Here, it's also important to understand and do your due diligence of existing IP. So any in-licensed IP rights, and to ensure the acquisition is bringing value. There may also be situations where it'll be worth setting up a local company, so a subsidiary, in the target market. So now we'll look at how to manage the intellectual property through these processes. So this slide shows a figure with the typical path on the top of from where an idea is generated to when it is commercialized, so when it goes to market. As you can see, IP creation is usually most intensive at the earlier stages during research, and then is reduced as you move through into the commercialization stages later on through development, manufacturing, distribution, and sales. Again, here on the left, you have the different modes of entry that we spoke about in the previous slide. And then on the right, in the gray horizontal boxes, this demonstrates the IP rights owner. But then again, as you move to into the later stages in the commercialization, you'll see we pop up some yellow boxes as you start to partner with others to license your IP rights. You are now sharing, so you're losing some of that control, and you're licensing those IP rights to other entities. But we will go through, there is still lots of benefits of partnering and licensing, even though you do lose some control, there's always risk, but there is great benefits as well to this. So we're going to go into a little more detail about each of the different modes of entry. So what is an IP license? So it's a right to make, sell, reproduce inventions and creations, use secret processes, and brand merchandise. So these are rights. If you license your IP to someone else, you are now giving them the right to do these actions. It's a tool to share the risks and rewards. Again, it's not just yourself anymore. You're now spreading that risk with others, and the responsibility as well. But by doing that, so again, yes, you're losing some of that control, but by choosing to license, you pass on some of the risk And you as a licensor now gain access to a larger market. You gain the support of the licensee. You've reduced your risk, and you can also gain access to additional resources that the licensee or the franchisee have available. A few other reasons of why you would license your IP rights. Financially, you can generate cash flow and you can improve your profitability because now you are extending your reach. So where you'd be working in a local market, well, now you can have licensees in different countries selling more of your product. So that does mean more revenue. You can access needed research and development or commercialization and manufacturing capabilities. So the licensee might have these local offices set up with manufacturing capabilities that now you have access to, or marketing and advertising. All of these are benefits that come with licensing your IP rights. It's also a way to focus the business. You can license out to recover research and development expenses, or license in other technology that whether you have gaps within your company, you can license in different technologies. It can lead to other business opportunities. And in some cases, licensing can result in equity positions, access to improved technologies, competitor information. You may gain access to foreign markets otherwise closed by trade restrictions and quotas. And you increase goodwill and reputation as a first step to establishing relationships in other countries. So I am going to pass it back now back over to Catherine to go through a few of the other modes of entry.
Okay, thank you. I see there's quite a few questions coming in. So maybe I'll take a short pause to try to address a few of the questions right now. But I'm also keeping an eye on the time. Just to confirm, we technically have till past. Is that correct?
I believe we end at 3. So
okay. So if we are ending in 5 minutes, I think we'll keep going and maybe do the questions all at the very end, if that's okay.
And if we can't get to something, we can also, I'll take note, we can send those responses to the appropriate people.
Okay, great.
Or to everyone.
I'll keep going then just in case, but thank you for your questions and we'll circle back. So sub-licensing, again, we're going yet another layer into commercialization opportunities, and it allows the licensee to further license all or parts of the granted rights. And so we're kind of getting into legal territory. I guess my take-home message on some of this is, honestly, a lot of this you will work with legal counsel, as in a lawyer, and to work out these agreements. That's not to say that you can't prep and think about ahead of time, how do you want to partner and who's going to do what, and arrive prepared. But in situations like this, you absolutely do need legal guidance to do this properly and make it valid and enforceable, and make sure you understand and have things clearly laid out. So for example, though, a licensee might receive the right to use the process. Maybe you didn't invent the process, but you want access to it because you want to manufacture and sell the resulting product. So maybe something was invented on the West Coast and you're going, wow, I think there's a market for it on the East Coast. I'd like to have the permission to manufacture and sell that here in Halifax, though the person who has the IP rights for it is in Vancouver. So the licensee may then turn around and also sub-license the right to sell that product to a distributor. Maybe I have a manufacturing plant and I want to manufacture it, but you know what? I don't have the distribution network. or I don't have the sales team who's going to get it into all the hardware stores, for example, just to try to make it a little more tangible and not so 20,000 feet. So maybe then I have the right to partner up with a distributor. So we have our inventor in Vancouver, me in Halifax making and manufacturing, and maybe I then partner with somebody else to help distribute for Quebec and the Atlantic provinces. And so then we're 3 layers into these kind of agreements. And sub-licensing agreements are very important in trademark and trade secrets. So either you want to protect how do we actually manufacture something, or also the branding of the final product that gets sold, that the consumer associates, I buy this particular brand of product because it has a good reputation. So for trade secrets, you also have to be really careful to maintain that confidentiality. Because remember, trade secrets, if the cat gets let out of the bag or the secret is revealed, you've lost your protection, and then you've lost a key component of your business. So that's an important aspect of it. So next, we're going to talk a little bit about some of the critical components of these types of joint ventures or partnerships. So here, for example, you're looking at some of what are the key elements or critical elements of forming a partnership. I sometimes like to use the analogy, and people laugh a bit, but there's some similarities in my mind, of a prenup agreement. If you enter into a relationship with something, who's bringing what to the table? So this can be corporations, but imagine it's 2 people who have decided to go into business together or form a relationship. Do you have a house? Do you have a car? Do you have kids? Who's going to be responsible for what, and who's bringing what to the table? Well, this is kind of the same thing on a company basis. So maybe a particular company, and it can be a small, it doesn't have to be a huge corporation, has some know-how and some background IP. And then the other corporation B comes with a distribution network and also some important background IP. So then when you merge the two, what happens to developed IP that you worked on in combination, and who has access to what? So again, like the prenup example, it's really important to have legal agreements in place so that everybody's on the same page as to what can you do, who's bringing what to the table, what are the benefits of those things, and how can that be all used going forward. And sometimes a company might want to spin off some aspect of a new development into a totally different company. So next slide, please. Sorry. So you could maybe, maybe you work in the IT space, but you've discovered a side product that you think would really interest your clients and consumers. And so maybe you spin off a separate side branch of the company from the parent corporation. And it can, again, involve assignment, it can involve licensing, and who has access and permission to use what that maybe has originated with the parent company, but you're going to still have access to use some of it in the spin-off to move ahead with a different segment of or target audience for that product or service. So sometimes research and development companies who want to focus more on what we call R&D will use this as a form of IP strategy to raise money and to carve off a segment. So when we hear about, especially the big companies like Microsoft and Apple or Nortel, they use these kind of arrangements in all kinds of permutations depending on what they want to achieve from a business perspective. So licensing does tend to be seen more with innovative startups when the future or value of the IP that's just being created, when it's all brand new and shiny, maybe you still don't know what all the market opportunities are. So you may start by licensing and see where that goes. But there can also be other circumstances. Once again, I would say in situations like these end up being quite complex, or can be. So working with a lawyer to figure out, what is your business goal? What IP do you have? And therefore then what's the best route to accomplish the purpose that you're trying to accomplish? For the next slide, I'm going to go back over to Giselle. Or did you want me to do this one as well? Sorry.
Oh, sorry. I had this one for you, but it's up to you. Okay, sorry.
No, that's okay. I can do that one. So again, really one of the take-home messages is intellectual property is just that. It's no different than saying I own a house or I own a car if I own a patent or I own a trademark. Once I own it, I can transfer the ownership between the seller and a buyer. If I own a car, I can sell my car to somebody else. Or maybe I can lease my car, or I can let somebody borrow my car. So intellectual property is no different. There's different ways I can assign rights or allow use of what I own and what the other person wants to use or gain from it. And that transfer can be made either as a lump sum payment, or it can be royalties. Maybe I give somebody permission to use my invention and create more copies of it. And for every unit they sell, they're going to pay me a royalty. And if any of you have watched Dragon's Den, sometimes we actually hear them talking about percentages and royalties and how's that going to work and how are we going to structure it. So unlike a license agreement, which grants the permission to use IP under certain conditions, as a general rule, if you assign it, you're transferring the IP rights from one person to another, or one company to another, and there's no ongoing obligation. It's outright going from me to you. But there are, as I said, many modifications of that, and they can come with any number of different rights, whether it's to sell, use, it can be for a period of time, it can be for a geographical area, it can be for, are you allowed to produce, publish, or perform something in terms of copyright. Think about a musician, who wants to perform a song. If they didn't write the music or the lyrics, they have to apply for permission to re-record that song, and maybe they pay a royalty, or maybe it can be assigned. Again, all of these things are negotiable, and you need to look at what's going to work in the best interest of both parties. And sometimes these legal agreements come with warranties that there won't be any third-party infringement. And if you transfer something, so remember my car analogy, well, if I no longer own my patent or my trademark, don't forget you have to notify CIPO, my colleagues, because we keep track of who owns what in terms of intellectual property rights. And it's important to keep those records up to date. And that's part of the reason we have a system of IP rights, to know who do I contact. Hey, I saw this patent and I want to start manufacturing it, or I realize that something has been registered and protected, but I'd like permission to use it. You need to ask. And so therefore, how do you go about finding who to ask for permission? That's why this system exists. Okay, over to you, Giselle.
Perfect. Catherine, I actually just saw, I just confirmed, sorry, so we do end at 3:30, so we do have some time to go through the questions. So before I go on to, I just have some resources to present at the end. I was wondering if we can go through some of the questions.
Sure, why don't we brainstorm on some of those and see if we can answer.
Perfect. So I'll go through the resources and I'll give you a chance to take a look through those. And then we can, if you can, whatever we can answer, you can answer. And then if not, we'll park it and we'll get back to everyone.
Okay, great. Thank you.
Okay, so while Catherine looks those over, thank you again for everybody sending in their questions. The last few slides, I just want to present some resources that are available. CIPO offers a number of training opportunities and information resources on intellectual property and different topics within IP. We also develop customized training materials in partnership with Indigenous organizations, different departments, businesses, regional offices. These are just some of the resources that I think would be useful for this webinar. So this video will be shared at the end of this presentation, and WEOC will actually also provide the links to these resources. So you can check the CIPO resources out on your own time. And if ever you do have any questions, we'll have our contact information on the last slide. You can always send us an email or give us a call. The next slide I have, those are CIPO resources. I've also compiled a few different governmental programs and initiatives specific to Indigenous support programs. So these departments have all put together a program specifically tailored for Indigenous entrepreneurs and different support resources, whether it be in the form of videos, fact sheets, grants that are provided. So I thought it would be useful to highlight some of these, and those links and resources can be shared with you guys as well at the end. And lastly, a great resource of CIPO, I think, is our IP advisors. Catherine is one of our IP advisors who's joined us today from the Atlantic region. So we do have IP advisors that are located coast to coast and are available to answer various questions surrounding intellectual property. So it's great because they do set up one-on-one consultations. So having that one-on-one phone call with one of our IP advisors to answer your unique and specific questions is very helpful for entrepreneurs and small and medium-sized enterprises. Their information, each of their individual contact information, as you can see, they do represent different regions. So it is available on our website. I have listed Catherine's information on at the end of this presentation, as she's one of our speakers today. But we do have all of these, their contact info on CIPO's website. So they can speak to a range of, it's a good starting point to understand the basics of intellectual property, how to leverage your IP assets, discussion on IP strategy and how to monetize that IP. So we introduce commercialization here, but if you had follow-up questions, that's a good place to continue that discussion, is to reach out to one of our IPAs. So just to recap on what we spoke about today, I'll just keep this short so we can get to some of the questions, but traditional knowledge and the IP system. So there are intersections between these two. The IP system can be used to benefit, so to help preserve and protect traditional knowledge. It is not a perfect system, but we spoke about and gave a few examples of how some products have been protected through IP rights using the IP system. We also talked about an introduction to different commercialization methods, so licensing, sub-licensing, spin-offs, joint ventures, so partnering. And these are just different entry modes. And again, there is more. These are just sort of some of the introductory commercialization methods. And we actually do have a more detailed presentation webinar on commercialization that goes into much greater detail. So again, if interested, you can always contact CIPO, and we'd be happy to share that information. And when in doubt, speak with an IP professional. Again, I mentioned our IP advisors are a great starting point for a discussion to help you answer your IP questions. And this is the contact page. So you do have my information on the right and Catherine's contact information on the left. But again, on our website, you will find all of our IP advisors listed and the region that they cover. So I will, so I'll turn it back to Catherine if she had a chance to go through some of the questions. If we don't get to your question, I will take note and we will share a response after the presentation.
Okay, great. Thank you, Giselle. So one of the questions is, what kind of things should an Indigenous video game studio be prioritizing? So that's a really big question, but I will say that from the point of view of whether it's software, apps, video games, we could probably do a 1-hour session on that, but I'll do the quick version here. Trademarks for the name of your game, and or potentially even some of your characters. If you stop and think about characters that are distinctive to your brand and your particular game, there are lots of examples of existing video games that have absolutely protected those aspects. If you're working in video games, software, apps, this is a big one, and I will spend a wee bit of time on it just because there's a lot of activity in those types of businesses and startups these days. Open source software. So for most of these types of things, people code, and for a lot of these things, people go to open source because why reinvent the wheel and rewrite code from scratch if you can tap into open source? Just be very careful of the terms and conditions of the open source codes and the agreements. So there are different types of open source licenses as to, fine, I want to go grab that little bit of open source code and use it in my product. Can you do that? Can you use that for a commercial product? And sometimes it's fine, sometimes you cannot. So be careful about that, and make sure you know the rules. Number 3, author versus owner. This comes up quite a bit in terms of video games, but in other forms of IP. Ownership as to who owns something can be quite important. If you hire someone on contract, the owner usually remains the person who created or did the work. So you hire somebody to build you a website, or you hire somebody on a contract to code something for you, unless it was specified in the contract, the IP stays with the creator. You've paid for the service. Be careful of that. I'm generalizing, but this gives you a rough idea. If I'm your employee, it's interpreted differently because employment contract rules are interpreted differently. Again, ideally you have a clause. When I worked, before I was with the federal government doing this job, I had an employee contract that I signed when I was hired. It clearly said that any IP I created in the day-to-day doing of my job belonged to my employer. Right now, as a federal public servant, same thing applies. So just be aware of the difference between employer-employee relationship and IP and contract. So important to be aware of that. You can protect some of what you're doing in video games, software, apps with trade secrets. And sometimes what you have might be protectable with a patent. So that is a very quick overview on something that I've given an entire 1-hour presentation about, to, digital incubators where everybody's working on apps, video games, software in that space. But it's a start. If you're looking for additional resources, please just send me an email or reach out to the other IP advisors. it's a question in an area we work a lot with. Okay, next question is quite complicated as well in a totally different area. So you know what, this is great. Welcome to my world. This is what a typical week would look like for me as well. If you've developed a new business model and are developing a well-being index for long-range metrics and curriculum for eventual licensing, and other organizations are already asking or inquiring for access to your business model, what should we do first? That is a huge question. Copyright will work on some of your curriculum. If you have a very specific methodology, it might, and a very big might, qualify for patenting. Once again, you may be able to keep some of it as a trade secret, and I would be branding with potentially a trademark. If you think about various sales training, Sandler sales training is trademarked as a methodology for training, say, salespeople. The Kawasaki method, I believe, for training musicians, that's being trademarked. So there's a number of tools, and again, we dip into our IP tools toolbox to try to protect various aspects, and we need to peel back different elements of what you're doing and what could you use to protect those different elements. So I would say something is involved in that, as that I would recommend that you book a one-on-one with one of us as IP advisors. Somebody asked, do IP licenses cover videos? Absolutely. You can get licensing and permission to use. Again, once an IP right has been granted and belongs to somebody, you can negotiate who gets the right to dip into it, use it, borrow it, take a part of it, take not a part of it, use it on the West Coast, use it on the East Coast, those types of things. Okay, next one. Just to confirm, Indigenous entrepreneurs in fashion and jewelry design should consider industrial designs or design patents if they have unique products. Yes, I would say absolutely. Possible geographical, if their designs are unique to a specific region. You could look into geographical indices, potentially if as a collective for, say, West Coast artists. I'm not entirely knowledgeable. I don't have a depth of knowledge on the geographical indication aspect of it, but industrial designs, absolutely, for fashion and jewelry. There are many examples of mainstream fashion and jewelry companies, so Tiffany, Lululemon, as well as Aboriginal designers. I'm trying, unfortunately, to remember the name, and we have a link on our website to a West Coast woman fashion designers who was using Haida motifs on woolen coats and jackets and scarves, and was using intellectual property to protect her designs. In addition to that, as an addition to that same question and continuing, if you've lost your protection, how can things be applied retroactively? It's pretty hard to go get protection after the fact. You really do need to try to protect at the front end. Totally different space, but I recently had a client consult with a company that had launched a product 2 years ago, and it was crazy innovative and really, really good. And they have tons of sales in Quebec, and it was copied by a company in PEI, as it turns out. And they now want to pursue and more or less tell the PEI company, cease and desist, stop copying our design, but they never protected it. And now they want to protect it, but it was 2 years ago. So they can't protect it as an industrial design anymore. I don't know legally what else they could do. That's, unfortunately, I'm not a lawyer. They will have to go talk to a lawyer with expertise. But from the point of view of could they now apply for an industrial design 2 years after the product was launched? No, they cannot. So that's a sad but take-home message to preferably protect what you have as soon as possible. Now, the name and the branding of that product being sold can't be copied. There they'd have a little bit more of a leg to stand on legally, even with common law, but that wasn't the aspect that was being copied. So take-home message, much better to try to protect. Okay. Do you recommend logos be registered for a copyright protection? So a logo cannot be protected by copyright. A logo would be protected as a trademark. I mentioned how there are many forms of trademarks. Again, we could do a whole hour just on trademarks, but we won't, not today. So trademarks come in many forms, and a logo or a design mark is protected as a trademark and again can be renewed indefinitely. And yes, we would recommend registering to protect. It's a lot cheaper to register and protect than it is to try to defend, because we work also on first to file is the underlying principle. So if somebody is going to scoop you, but you were there first, it gets really messy. And the lawyers and the law courts are the ones who tease this out. It's a lot easier and cheaper if, yes, you protect and register your logo when you launch or as soon as possible afterwards. Now, for a logo, you could launch your product and your trademark, whether it's the name, the brand, the logo. You can launch your product, and 2 or 3 years after you've launched, you can then still apply for trademark protection. There's no minimum or maximum window there, the way there is for a patent or an industrial design. Whoops, wrong mouse again, sorry. So I think that is the end of the questions that I see in the chat. By all means, my other co-organizers and participants here, if I've missed something, please unmute and speak up.
No, I've gone through. I think that's all the questions that I see as well.
Okay, well, so I will just close us up then and thank Giselle and Catherine as always. It's been a really, really great season this fall and winter, and I think I was especially looking forward to this presentation because it's just a really fascinating bunch of details, and there's a lot in there. And so because of all of that information, we'll be posting a link to the video on our website at weoc.ca tomorrow at the latest, but we will also send it all to all registrants through that Eventbrite email, and any links that Giselle and Catherine also want to share with us and get out to you. And feel free to reach out to them. Their information is still up on the screen. And thank you, everyone. I just want to give a little last pitch to the fact that we have a French version of this presentation, December the 17th, if you missed that off the top. And also a little just note that at WEOC, we have a survey out right now for women entrepreneurs that we would love anyone interested to take, and you can find it here. I just put the link in, and it's open for a few more days. So I'm really trying to get a diverse voices and find out everything we can about how women entrepreneurs specifically in Canada are being impacted by COVID and how they're moving forward. So I would really appreciate you taking the time to fill that out if you can. I think that's it for us. Thank you everybody for coming this afternoon, and we will see you again. Thank you.
Thanks to everybody, and thank you for inviting us. And just remember, at first it's complicated, but it does get easier each time you hear a little bit more, and you can build on that base of knowledge, and we're more than happy to help.
Thank you. Thank you to everyone.
Thanks. Take care and stay safe, everyone.